got a good taste of the best practices, and so he is a very deeply passionate person for knowledge and for research, and I'm really looking forward to hearing from him on a very important topic. There was for last several years there was a absence of legal codification in the field of data protection. There have been attempts, critiques, and then there was the Justice Sri Krishna committee, and then which worked on it, and then finally some legislation was there, and but it was there were so many loopholes, and if you look at the European standards, they are fairly well established and very high standards, and today we need what we call codification on the data protection, and I'm really eagerly looking forward to hearing from him, and I once again welcome Prof. Indranath Gupta to Orbit University, and we hope to have him again and again, and thank you.
Thank you, sir. We are grateful for having the opportunity to host our speaker, Professor Indranath Gupta. Professor Indranath Gupta is a professor at Jindal Global Law School, Dean of Research and Controller of Examinations, and Academic Coordinator of the Jean Monnet Chair Group at OP Jindal Global University. He is co-director of JGLS and senior fellow at the Jindal Institute of Behavioral Sciences. Professor Gupta was earlier appointed as the research collaborator by the University.
No, actually it's very important. Everybody please carry on.
University Bocconi, Milan, Italy, for a project funded by the European Commission under the 7 Framework Program. He has taught at the Brunel Law School of Brunel University during his PhD and has been involved in a funded project on information privacy. Professor Gupta has participated in many multi-jurisdictional projects on digital era competition against you. Professor Gupta holds a PhD from Brunel University, London, and 2 LLM degrees taught and research from the University of Aberdeen, UK, and the University of East Anglia, UK. His PhD looked at the transnational influence of the US Supreme Court's judgment in the Feast case in the framing of the Database Directive in the European Union. He specializes in technology law and aspects of intellectual property law. Over the years, he has offered courses such as informational technology law, music and copyright, and EU law and approaches to new technologies. Professor Gupta has contributed in reputed journals which are indexed in Scopus and reputed rankings. He has worked extensively with a global reputed publisher, Springer, and has several books to his credit. He has also been invited as Jean Monnet Visiting Research Fellow at the Center of Excellence Jean Monnet Center for Intellectual Property and Management, Bournemouth University, UK. The Jean Monnet Chair that Jindal Global University received includes Professor Indranath Gupta, the Chair Academic Coordinator. The Jindal Global University Jean Monnet Chair will contribute towards strengthening, deliberating and implementing EU studies, and in particular EU data protection framework by creating a specialized project with the overall objective of institutionalizing it within the multidisciplinary and interdisciplinary academic framework of the university. The vision of the multidimensional approaches to the understanding of the EU data protection framework project is to create an extensive and rigorous academic resource pool in the given area to facilitate capacity building exercises for different stakeholders. The wider implication of the courses and research conceived under this project will not be limited to a particular discipline, but will add value to the understanding of a wider audience connected to different disciplines. Without further ado, I would like to invite Professor Indranath Gupta to enlighten us with his words. The floor is all yours, sir.
Thank you so very much, Professor Murthy, for inviting me. Thank you so very much for your kind words. Professor Murthy likes me a lot. I really feel embarrassed whenever people read my bio in front of me. I do not know whether I can enlighten you, but I can share a few thoughts, and I'll try to do that. So, the topic of the day, a perspective on data protection law. At the end, probably we'll figure out what that perspective is. But I want to tell you a story and a few of the concerns that I have. I've been working with a colleague of mine, Parth, on several articles, and there is one article that has been published recently in 2022, or was it 2023? Maybe in 2022 end. That looked at the issue of transparency and data protection. But that work was just a beginning, and I want to share a few thoughts with you as to how I see the walk to progress. Once, and therefore, and what are the complexities, what are the issues that are present, and so on and so forth. So I'm going to talk a little bit about that. Professor Murthy just said, it has been quite a while that India is talking about a data protection law, comprehensive data protection law. The idea is not that new in India. Literature on informational privacy, law on informational privacy probably can be located somewhere in the Information Technology Act, say following 2008, 2009, around that time. But still we need to have a good hold on informational privacy, have a comprehensive legislation. You all know about the 2017 Supreme Court judgment. You know about the relevance of Article 21. So I'm not going to get into that. You know the framework. Informational privacy is therefore an extremely important issue for multiple reasons. Not only it is mandated by the law of the land, but for other reasons. And the primary reason why it is important is because it gives the right back to the individual. What I meant by that is you decide the course of how your data is going to be used. And when I say data, I mean personal data. And when I mean personal data, it could be anything between your name to your ID, to your email ID, to your bank details, to whatever affiliation that you may have, and so on and so forth. It may include health records as well. So for all good reasons, we should have control, we should decide. But of course, it's not an ideal situation. So at times, it's not only just India, but in different parts of the world, we'll see that some of our rights been compromised, some of our rights been sort of challenged, it's difficult to ensure that we keep to those promises. There are multiple other things. And it is not just India. It is in the European Union, it is in the UK, it is, say, it could be in Thailand, it could be in Indonesia, it could be in China. Anywhere you go, there is a talk on informational data privacy, and people are worried about it, at least that is what we perceive, and we want to work on it. Now, that's the context of informational data privacy. But in that context, there is a final point that I want to discuss today. And that's about transparency, the issue of transparency. Now the issue of transparency is, if you ask me what is transparency, I wouldn't be able to define it for you. I may be able to illustrate for you. But technically speaking, transparency is a cumulative effect of multiple activities that a data controller undertakes. Who is the data controller? Anyone who is processing our data. Our meaning us, people like us. In India, the proposal is to have a data fiduciary instead of data controller. But we'll take that universal term of data controller as envisaged under the GDPR in the European Union. So what is this? If the transparency would be a culmination of different factors, what are those factors? What are those practices? Now, there are different practices. For instance, you need to know about you as in we. We need to know about the existing privacy policy, say for instance. Who would provide that information? Is the data controller providing the information? How would the data controller provide the information? What is the role of consent for that matter? How consent will be useful in all these things? How the consent would be presented? Who gives the consent? Who collects the consent? So data controller plays a pivotal role in all these things. Your practices as a data controller essentially would lead you to the zenith of transparency. So if we can think transparency as a scale, there is 0 at one end and 5 at one end. So it is your practices tending towards transparency. As it, you would remember, limit tends towards infinity. Those who did maths and differential and calculus. And therefore transparency is an ideal situation that you are aiming to reach. Now within that transparency and those activities, there is one attribute which has received some attention. And what is that? It's a phrase, and my entire talk is about that phrase. And that phrase is clear, plain and simple language requirement. Clear, plain and simple language requirement. What is that? What is it in context? Well, the law, and it is not just European Union, but in India, at the stage of the proposal, different committees have talked about it. In China, in Philippines, in Thailand, in Indonesia, in Australia, in Singapore, wherever you go, they use this phrase, clear, plain and simple language. And that is where our question started, that what is the threshold of clear, plain and simple language? Because there is a tendency to understand that clear, plain and simple language is nothing more than a script. Either it could be in Bengali, it could be in Oriya, it could be in Hindi, and so on and so forth. But we sort of looked at it, we, when I said me and my colleague, we said that look, clear, plain, simple language can't be just a script. It is not possible that it remains within the confinement of just a script. It can't be, it is in English and therefore it can't be in clear, plain and simple language. So that was my primary question. Well, what's the world's view? And let us, when I say world's view, it's too much, but maybe take one jurisdiction here, just to give you an example. Let me take you to Netherlands, right? Recently, well, it's been 1 year, I should still say recent. You've heard about TikTok, right? Now, TikTok was fined in Netherlands by one of the bodies that would adjudicate data protection matters. And they were fined because they were dealing with children. I mean, they were customers. So people like us, these are adults, we are adults, but customers were children. And whilst engaging with the children, and now you can ask how were they engaging? At the first level, they were engaging by stating the privacy policy. While they were engaging with the children, they provided all details in English and not in Dutch. The adjudicating body came out with a decision saying that if you are providing information in English and not in Dutch, then you are lacking in transparency in some manner. Because people wouldn't understand. Even if they are proficient in English, they are less likely to understand English if you're in Netherlands, right? Now if you do an analysis of this decision, one, therefore, what they mean, that language essentially would lead to understandability. I'll come to that. And second, what if those who are not proficient in Dutch yet settled in Netherlands? What would happen to them if everything is published in Dutch? So I'll come to the first point because that's a sub area that we're talking about. This language and understanding it has led from clear, plain and simple requirement to the language requirement, then to the understandability. We have come up with a proposition that language and understandability, they do not always go hand in hand. While we are speaking, it may mean something. While we are writing, it may mean something. Yet when it comes in the context of data protection and privacy, they do not always go hand in hand. I'll give you one reason as to why I'm saying this. Well, I'm saying this because where are these conditions written down? They are written down as a part of the privacy policy. They are written down as a part of terms of use and so on and so forth. Where would understanding come from? Well, the understanding would come from first that you are reading it. Now that you are reading it, and then you would be able to understand what the other party has conveyed. More than often, we do not read the terms of service or the privacy policy. I mean, if you would ask me, I probably have read once or twice, and therefore I refrain from using some of the services. And I'm sure that you as individuals who are well aware of different legal perspectives haven't really gone about in looking at the privacy policy. So if I would ask you, well, Professor Ghosh, what is how your data is stored by Instagram, where are they stored? You probably wouldn't be able to answer. Prashant, what is it? What Facebook does with our data? Whether it remains within India or whether it goes outside India? And all these conditions are there in the privacy policy. And the DPA, or the Data Protection Authority in Netherlands, said that if I provide everything in Dutch, then there would be automatic understandability. Otherwise, there is lack of transparency. And we sort of criticized it, saying that if I do not read it, you are relying on a document that I do not read, and you are saying that my understandability is associated with the language. It's on a false presumption, and you can't have that kind of pathway. So, what is the recourse when it comes to understandability? How do we progress? And that is where the paper ended, saying that understandability has to go with the reading of the document. It is not reliant, it's not upon the script that the data controller is using, it's much more than that. In fact, if you turn your attention to India, the data protection law, the draft bill, it's talking about that it should be in all possible languages under the HU. Which means the 22, if my memory serves me right, the 22 languages that we have. Now, does it mean that by just using those 22 languages that you would lead to the question of understandability? Why understandability is crucial? Because if you're talking about consent and informed consent that been shared by the data subjects, people like us, to the data controller, those who are processing the data, how can you ignore understandability? Is consent or an informed consent a meaningless activity in the framework of data protection? It can't be. Because around the world and in India, notice and consent framework is the framework that is followed. Meaning, you notify, you understand, and you provide consent. So where is understandability? Understandability kind of is lost in the entire scheme of things. It seems that it has now become a checklist activity, that you have done something, you have made clear, you have provided in that language, and the rest is on the data subject. People like us. You understand, you do whatever, we'll process. But I see a problem, and this is where we want to proceed. I see a problem because see, the entire objective of a data protection law in any country is is circled around the data subject. It is the data subject. We want to give the right back to the autonomy back to the data subject. Yet we are reducing it to a checklist activity. We are minimizing. We are making things trivial. So therefore if understandability is a core issue which is not followed, and language is the way they feel that understandability would be reached, and that is not the right approach. What is the right approach? Well, one way is to ascertain that we can do an attitudinal study of data subjects and what they see, how they perceive consent to be, and what are the steps that they can take to ascertain, okay, these are my ideas, this is how I see consent, this is the privacy policy. And then we come up with some sort of idea framework that this is how they perceive understandability. The other half is the data controller's perspective. Remember that the lens can't be just unidimensional. The lens must be multidimensional. So it has to be the lens of the data subject vis-a-vis the data controller. So if I'm using the lens of a data controller, how would they look at understanding? It would be dictated by the business model that they have adopted. It would be dictated by the innovative measures that they adopted. So their level of their perspective of understandability and our level of understandability, whatever study that we do, they should converge. So much so that gives us some meaning, so that the regulator can say, oh, there is understanding. So it is a difficult task. It's a serious task, because I do not know what people think about understandability, privacy, data protection, and so on and so forth. Even if we do a study of such magnitude, it would give very different results in different parts of the world. Right? Whilst there are certain similarities in terms of data protection legislation in say most of the countries, meaning they follow the data protection principles, but they would be giving different results. The problem is, if they give different results, there is a constant data flow that happens amongst nations, and a level of uniformity it's crucial to ensure the data is safeguarded in a manner which you would expect it to be. So there are additional complexities. So that is there would be certain shortcomings even if we carry out a survey. Even if in India or 5 countries, but doesn't mean that is how they perceive, and therefore that is where we have to. Companies would have different models altogether. There are different companies, for instance, some would rely on data, they are data aggregators, and they completely rely on a reuse of data, right? Their business model on reuse of data, so they would have a different standard to sort of look at. So we see a lot of divergence. Of course, I do not know whether they would meet. That's the work in progress. But even if they meet, there will be a lot of sharp edges. So for a regulator in a country, in a jurisdiction, when there is a trans-border flow of data, there will be a lot of difficulties in ascertaining what the approach should be. So one way of looking at it is, okay, let's think of a standardized approach. What does that mean? Well, it takes me back to those days when we started transactions online. For instance, we do it online all the time these days, banking online, all stuff's online. But there used to be a time when we were hesitant. We weren't sure that whether we are the right website. We weren't sure, someone probably is snooping, right? Someone is capturing our data and so on and so forth. How did we resolve that problem? It was not a problem that was resolved by law. If someone would say, IT law resolved that problem, because of IT law there was a deterrent effect, and therefore I would say maybe not. But it was resolved through a technical means, through a standard. And that standard we all know, that is the HTTPS, or the secure website, right? Which is a third-party vendor website. If you open any website for that matter, a bank, financial organization, you will see that it's all the secured server, right? And that S represents secured. And if you click on that, there is a padlock, you will see a certificate, and you will see that from when to when the certificate is valid, and when the data transfers through their website, it is secure. So that standard is a technical standard. And that ensured that it is resolved and we don't worry about it, banking and other stuff. Now we can freely give our data away, at least punch in data and so on and so forth. So that way I feel a standardized approach can actually clear out the expectations of understandability as well. If we have, like for instance, what we propose would be a universal language. And that universal language can be just symbols. For instance, if you are going to, this is a simple example, if you are going to a place, you do not necessarily understand the language of that place. You go to Spain and you prefer vegetarian food, what would you be looking at? You would be probably looking at a green dot. And if you prefer non-vegetarian food, you probably would be looking at a red dot. Now there is certain universality which is connected to that red dot and green dot. Same would be with traffic signals. You would probably know something very similar happening in different parts of the world which you are aware of. So we have to bring down that understandability represented by symbols, so much so that I or we as individuals or data subjects need not go through an entire document to understand what data controllers have said. On the other hand, data controllers need not sweat it out thinking that data subjects would understand and therefore we should present in 22 different languages. So that standardization essentially would be the key factor. Now what the format of the standardization would be for a particular data controller is again a difficult question, because it will be sectoral in nature. So what kind of data controller you are would decide on what kind of standardization approach that you have. Countries have thought about it, but still it's a long way to go. So just to conclude, in a nutshell, a lot of reliance is on the data subject's understandability. I believe we are barking up the wrong tree by polishing off privacy policies and expecting data subjects to understand. I believe that there will be a lot of discrepancies when it comes to what understandability actually is, using the lens of the data subject or the lens of a data controller. And let alone they wouldn't converge, they would probably intersect, and I am not sure, taking the example of a Venn diagram, that common space, how broad that common space would be. And I think that would be quite narrow. Narrow so much so that no regulator would be able to point the finger on that. Ultimately, it would be a futile exercise. So standardization could be one of the approaches, one of the solutions, which would take away the tension of the data controller, take away the apprehension of the data subject, and the world would be a happy place to live in. Will I stop here? Thank you. Please feel free if you have questions. Of course, I haven't particularly talked about India, but if you have any questions about India, please. Kajal.
Thank you so for your insights on the understanding pursuit. My question is about the new Data Protection Bill 2022 and the concept of deemed consent. Yeah, how do you think deemed consent will be regulated? Because I think Singapore somewhere notifies the user and they have some regulations around it. But in India, how do you think?
See, the question, it's an extremely good question, right? We are working on an article, of course, it is not final as yet. And the tentative title, maybe once it is published, I'll pass it on to you and all of you. What is left of consent when it is deemed? That is the title of the article, right? So why deemed consent in India? I think that's the first question that we have to ask ourselves. What is the role of deemed consent? And we have to use the lens of a data controller and the data subject as we have used it. When you look at the deemed consent, so that the deemed consent starts from the consent itself, although it is a paradox. The draft talks about that you can only process if there is consent. That is how they have started. Then they have moved on that there is a provision of deemed consent, and then they have listed out few of the activities that would come under deemed consent. The first activity, if I remember correctly, is relying wholly on the understandability and reasonable understandability of the data subject. We walk in a restaurant. I think this is one of the examples that they may have also shared. We have given our phone number and name. The law is saying that the processing would be under deemed consent. My submission is the following. I have walked in, I have shared. What is the purpose of you as a hotel collecting my data? Well, the purpose, I can see that, if there is a change in a reservation, you probably would be notifying me and no more. The question of deemed consent then therefore comes in here and say that, by the way, when do you plan to delete my data? Is it going to happen when I've ended my meal? Or is it at some other time? The problem with deemed consent is there. Therefore, the deemed consent is based too much on reasonable understanding of a data subject who may not be even aware of data processing or the idea of data processing in the first place. And if that is what it is, then there would be over-processing. Processing of personal data would not actually be based on the purpose of collection and something else. So deemed consent, there are other examples. We talked about Singapore. There is another concept in the UK as well, which is called soft opt-in. Again, soft opt-in is a misnomer. It's an opt-out. Okay? Meaning what? We receive a text message saying that this is the this is the offer that you have. If you do not want to receive this message, you may unsubscribe. And you can click on the unsubscribe and you think that you probably have been unsubscribed from that service. That's soft. It's more of an opt-out and not an opt-in. There is a problem here. The way the data protection ecosystem is structured, if you go back in time, say 3 decades back, so 1995 was the data protection directive in the European Union. Even before that, if you go back in time to see the OECD guidelines on data protection, it can't be based on an opt-out version. Well, if you based it on an opt-out version, that means you've already processed it. It's just like those who are interested in IP, of course, barring fair dealing and fair use, you can't publish everything and they say if you do not want, we'll remove it from the market. You can't do that. So it has to start with your consent. Now, why deemed consent is there? I also understand the perspective, because we have to look at it in a nuanced manner. See, there are concepts, it's not a new concept, there are concepts like consent fatigue, which essentially means that you've been asked consent too many times. So all day long you have been consenting, right? And you have not done any work other than to consent, either updating policies or something or the other, and so on and so forth. And then it becomes a mechanical activity without having any understandability, because that is at the core, which I was talking about. Now, so what can be done to remove that concept fatigue? And there is no good answer. I mean, if you'd ask me, even the notice and consent framework is also fraught with uncertainty. It is not an ideal situation, but we are yet to develop a better situation. Let me put it this way, right? So, to avoid that, deemed consent would be one of the options. The other thing is that what kind of business model would you develop if you continuously be asking consent, right? So that's the data controller's perspective. You know, the interesting bit is that whilst the data protection law is governed in and around keeping the data subjects in mind, the data subjects are nowhere. Because there is a perception that data subjects understand so many things. There is a perception, not in actual terms. So if I would say deemed consent, the first pointer is on reasonability, my reasonable understanding. If I do not understand, then what am I understanding? And how am I passing on consent? And what happens once the meal has ended? Yes, please.
I do have a question, but I do want to say that, it's been long since I attended those lectures about data protection law in my LM classes, and I just want to share with everyone. They used to be like 3-hour lectures, but nobody would ever get bored. Sir wouldn't take any break, but the whole lecture would just, connect like a story, and you could understand the most complex subjects, in the form of a story, and every dot would get connected. Sorry, sir, for further embarrassing you. My question was, sir, you spoke about...
Amazing this again.
Yes, sir, I mean, every lecture, sir, I'll tell you, I used to attend these classes over weekends, but, and I traveled to Delhi, but those 6 hours I could sit and, listen to it. So, now I'll come to my question, sir. You spoke about, like, moving away from the current process, which can perhaps cause consent fatigue, and probably moving towards a process where we start setting some standards. Now, do you imagine this happening at the domestic level, or an international treaty about privacy law is the way to go? Because we are talking at the international level and we're talking about cross-border transactions, and in all these processes, unless there is an international level treaty which at the scale of the WTO law, like which is comprised of like 18, because we're talking about different sectors here. So WTO law comprises of like 18 different agreements. So similar way, unless we go similar way, can be ever implemented, because EU can do this within its own region. Some other regions can also come about without an international treaty.
Now this is off the records. No. I don't think a treaty will happen at all. Ever. I'll tell you why. Because of the different business models, and I was referring to that in the morning's meeting as well. Companies survive on data and reuse of data. Why do you think major companies that were fined in the European Union, right, by data protection authorities, were all those who have not been incorporated in the European Union? The highest fine thus far, Amazon in Luxembourg, fined for an amount of, I think, 677 million euros. So, there will never be a treaty, so to speak. However, what I perceive, at least in the 10-15 jurisdictions that I have been following, that there is sort of an understandability and agreement saying that they have to do something about it. At least that level that they have reached. What they have done after that, they have come up with at least 8 to 10 odd principles, data protection principles, that are kind of uniform anywhere you go. So there is an agreement in an organic manner. They have not agreed, but there is an agreement in an organic organic money that actually has percolated through different layers, and that has happened, which is a good step. However, even if we have the data protection principles, I'd say that these are broad principles. So you have to collect what you need. You cannot over-process. Now, how one jurisdiction interprets that and get it into a legislative structure is something that we have to look at. So we would identify those principles. But those principles, there are differences in opinion as to how those principles have been actually transposed in their legislation, global legislation. See, another point that would probably be interesting is who has the bigger market? So, whether you want to do business, EU has been really successful in sort of creating a global consensus through GDPR, not copying GDPR, but through GDPR, because everyone would like to do business in the European Union. And if you want to do business in the European Union, you must follow GDPR. There is no other way out. So market would play a very important role. After a very long time, United States been taking baby steps, and I said baby steps because slowly they are beginning to come up with at the state level different laws, and at the federal level they're thinking of a comprehensive data protection law, because they also feel that is their market is becoming important for the world. So it's dominated by players who probably can dictate how the law should look like. So you would see closer resemblance of a data protection legislation. So for instance, jurisdictions like Philippines, jurisdictions like Thailand. These are important jurisdictions not in terms of the size, but amount of data that they are processing. Very similar to what GDPR has talked about. So there is a lot of movement that is happening, and those common principles are being kept, not in a locker, and they have locked it in and lost the key. That they have not done. But at least what they have done by following those principles, they have come up with something very similar. So you can see concept, you can see those principles, and so on and so forth. But at that level. But if you talk about a global level, a treaty, I see a long way, because I don't see that is happening for the simple reason it's market dominated. See, also I'll tell you something, there is a lot of talk that is happening. We talked about personal data protection, right? There is a lot of talk that is happening on non-personal data as well. And non-personal data and anonymization of personal data and use of it. Because they want to, no one can neglect the importance of data and the marketability of data. So what is happening right now, EU, after GDPR, they have come up with the Data Governance Act. Just recently, I think in June 2022. And the idea of Data Governance Act to ensure use and reuse of data, and the data remains in circulation. Because they have a fear that with GDPR in place, with a lot of restrictions in place, they wouldn't be able to dominate the market. So they want to increase the data flow. So this is another thing that is happening. In India, something that perhaps you know, but anyways I'll share. If we say 2017 the Supreme Court judgment, then with the 2018 the BM Shri Krishna Company's report. 2019 was the first draft which was presented. But after that there were a lot of movements. So for instance in 2021 the Joint Parliamentary Committee report came. And 2021 also the Joint Parliamentary Committee suggested that why not you have a data protection bill of 2021, and they sort of merged the two documents. So one important thing that they said is about personal and non-personal data. So what I'm trying to say is there is another dimension now that is added, and why it would be very difficult to have a treaty. So this said that in the digital economy era, it will be very difficult to figure out when personal data becomes non-personal, when non-personal data becomes personal, because we are thinking of transfer of data from one to one, you to Facebook, you to Amazon, but soon there will be one to many, use of Internet of Things, and so on and so forth. It will be very difficult to ascertain when this personal data has become non-personal. So these lines are now blurred, and there is enough fear that non-personal data would then go back reversed, and maybe in anonymized form, reversed and become personal data. So they went on to say that, look, anonymization is not a solution, because there is a lot of discussion that is happening. Any jurisdiction that you go to, they would not like to put anonymized data within the scope of data protection. Or, you just look at GDPR, that is what they're talking about. Now, what JPC committee report is saying that anonymization is not foolproof. So if personal data which was personal before anonymization, if that process is reversible, then it would go back to being personal again. And you do not know when this change will happen. It's so dynamic. Therefore, let's have the personal data and non-personal data both under the data protection framework. In fact, they changed the title of the bill. They said data protection bill and not personal data protection bill. Which again meant that a lot of emphasis is on data and its use. And whilst that data and its use remains quite firmly grounded in different jurisdictions, it will be very difficult to have a treaty mechanism. You can have trade agreements being discussed amongst nations. They can do it from one to one. They are already doing it. EU has listed out a list of adequate countries where they can transfer data without any further requirements. But those are between 13 to 14 countries. So that's an arrangement that they have gone about in doing. But reuse and use of data and non-personal data and personal data which been anonymized, that will remove the deal. It will be very difficult to have something at the international level. Sorry, I think we have
Many follows, but will be unfair to others.
yeah, I think you
I previously was denied an answer, so I thought I'll take this opportunity up to. So, as we have seen in the new PDP bill of 2022, there is this requirement of data localization, and any data being shared outside the jurisdiction of India will require an express authorization from the central government. This seems very different from the earlier iteration of the bill, which had a further more complex categorization. So how do you think that this will affect, because most of the times we end up sharing data which is of course stored and localized outside the jurisdictional boundaries of India, and how many countries can, and how will, on what criteria they will define those countries, and on what grounds we can rather share our data and not share our data. So it is kind of a complete absolute power in the hands of the central government to decide over how to share data, when to share data, and with whom to share data.
I'll tell you, thank you very much for this question. I'll tell you, it is not limited to India. What is this adequacy list that EU has created? At the level of the Commission, they decided that these will be the countries where the data can transfer. What our central government is going to decide, right? But what I would say that I'm sure, future drafts would have that. There are three broad ways in how data is transferred. Three broad ways. And just not limited to India but all around the world. One is an adequacy test. There is no clarity as to how the threshold would be measured. I can give you the EU example. They said it should be equivalent and not same. What does it mean? I have to take you back to two different cases that happened in 2015 and 2020. Those are the Austrian cases. Those are the famously called the Schrems cases, right? And where the validity of the safe harbor agreement and the privacy shield, they were invalidated rather by the Court of Justice of the European Union, right? CJ. So therefore, that was a special arrangement, right? So list of adequacy is something, it should be similar, and those cases said, the CGU said that, no, if you have any concern about the data, if a member has a concern about the data, or a resident has a concern, there is no other course. You go to the United States, whom do you ask? What is the process? Who would stop the enforcement agencies from not using the data? Who would stop? Is there a process? They didn't have a good answer. The second time, the same question was asked. They had an ombudsperson, but then ombudsperson had no control whatsoever on law enforcement agencies in the United States. So they felt that it was not good for European data to grow. And now the Biden leadership essentially is working on another framework, the third framework, as we speak. But the list of adequacy in the European Union would be looking at comparable as long as there is an option for any grievance redressal mechanism and is following the rule of law. That is what they are after. Some countries, and there would be a caveat that I have to introduce here, because it was a translation that I read, and they said that either same or greater protection to come with that list of adequacy. Now in India, some countries I am talking about, this is Thailand. In India, they have come up with just 1 degree. So adequacy is something that the central government will decide from time to time. This is however you want to do it. The second level usually used for transfer of data is binding corporate rules. What are they? Essentially, their rules been approved if data been transferred from one undertaking to another undertaking in different jurisdictions. So that's binding corporate rules. And the third one, which is the most prevalent one now and which has been amended in the European Union and do exist in different forms in different jurisdictions, would be the standard contractual clauses, or the SCC. Now, these are the broad ways in which data controllers can transfer outside. One problem that I would say, although you didn't ask, but since you talked about transfer, I'll tell you something. And this problem remains in each and every jurisdiction, is about processing data that relates to children.
Yes.
The verification process and the stages that are there, at least mentioned under GDPR in India, in the proposals, in wherever you go, it's quite interesting, not in a positive way, right? Because a lot of onus is on the parents. But what is the process that data controllers would take is not very clear. Now, if I were to give my name, my date of birth, and pretend to be an adult, if I've not been verified, say a child who is of a certain age and who doesn't report the right age or the year of birth, that child would be treated as an adult, and the processing would happen as an adult. The transfer would happen as an adult, and if there are problems as to transference problems as to transferring of data from one jurisdiction to another, just think that data related to children even can go to a different jurisdiction. So this is one of the crucial problems that are there, in transparency. But transparency, adequacy list would be determined by the government only, and that is how it is done.
But the problematic part is that there is no criterion defining the two.
So the criterion, usually I told you, if you compare it to different jurisdictions, essentially is either similar or greater, that could be one, or there is a grievance redressal process following the rule of law. That is what is being followed.
It's a broad definition.
It's a broad, right? But we have to wait and watch. I mean, I'm sure there will be. I've heard that July is when the bill is again going to be presented, right? And there have been comments that have gone, right? I mean, in fact, all of the countries, important jurisdictions have already come up with the data protection legislation. Sometimes my students do ask me when I offer this course, that, sir, have you wasted time? I said, no, we haven't wasted the time. We have the advantage of jurisdictions who probably have worked on data protection and haven't worked on, and few things haven't worked. We need to ensure that we do not follow the same route. But you know that the title of the bill is digital personal data protection. So there is another problem with non-digital.
And I guess, but if we see the Puttaswamy judgment, it covers both the digital.
All. Not only Puttaswamy judgment, but also the different reports at different times. You can't possibly think of. Otherwise, you know what will happen? Data would be recorded in a non-digitized form and kept
And stored.
That's
It's just not on servers, but in documents.
in documents.
But does it create an accessibility problem also? Because a lot of organizations, they might stop providing you the services because, or probably you getting an accessibility towards those services just because you are not ready to share your data. How does that works out? Because ultimately, in this digital economy, in this digital world, we need accessibility to those services. And if there is a denial of services, it goes against the whole spirit of what this digital economy stands for.
Yeah, see, the problem is how you go about in recording data, right? I have a feeling that probably will move from just digital to personal. I would say, I think we should do it, cover all. Then there would be greater transparency. And then be easier for even data controllers or data fiduciaries in India, right, to even operate. Data principals can then ask for data, have accessibility, right? And why ignore those data which has been used? I mean, in fact, all jurisdiction talks about data in non-electronic format as well. Because there is equal risk in all forms of data.
Thank you, sir, for such an insightful lecture. Thank you for addressing all the questions as well. Now I would request Professor Bayasamurthy, Vice Chancellor in School of Law, to felicitate Dr. Indranath Gupta by presenting him a token of appreciation.